Good afternoon, everyone. Welcome to today's High Impact Real Estate webinar. Our topic for today is PI Act on trial. Should South Africa's eviction law be amended? And is it time for reform? I'm Neale Petersen. I'm the founder and editor-in-chief of Real Estate Investor, and I'll be your moderator for what promises to be a power-packed, very insightful session. And a very special welcome to all our attendees joining across from South Africa. Thank you for investing your time with us today. And today's session is proudly brought to you by Real Estate Investor, South Africa's premier property marketplace. And for those new to REI, just welcome. Since 2007, we've been a trusted voice in the South African property space. Our mission is simple: to inform, connect, and empower property investors, professionals, and entrepreneurs. And we do this through our monthly magazine, Real Estate Investor, rei.co.za, our property news and learning platform, our weekly webinars, interviews, and newsletters, and also our live event seminars and networking opportunities. Just go to rei.co.za to explore more. Some housekeeping just before we dive into our session. It will run for full 60 minutes, and we've got a Q&A box at the bottom. We want your engagement, so submit your questions, and we'll cover as many as possible in the live segment. This webinar is being recorded. Yes, it is. It's normally on the top question that we get, and the replay link will be shared with all the registrants. So why today's session matters? Well, with unlawful land occupations rising and Parliament actively considering amendments to the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, PI. This session couldn't be more timely or more urgent, and we're entering a high-stakes moment for South African property law. This isn't just about legislation, it's about investor confidence, housing stability, constitutional rights, and economic freedom. And today we'll explore whether property owners are fairly protected under current law, the real-world consequences of proposed amendments, and how to balance property rights, human dignity, and the housing crisis. So if you're a landlord, an investor, an attorney, a property manager, or policymaker, this is a conversation you need to hear. So we're joined today by three outstanding legal minds and thought leaders in this space. First of all, we have Martin van Staden. He's the head of policy of the Free Market Foundation. He's a respected constitutional analyst and staunch defender of property rights. And Martin brings a critical lens to the PI Act's constitutionality and economic consequences. So welcome to you, Martin. Do you want to give a shout out and to the audience out there?
Yeah, just to say thanks for having me, Neale. This is a very important conversation, and I'm glad we are at a point in South Africa's development where we can have a frank conversation about this now, because it was quite taboo a while back, but I think we can now speak openly about some of these problems. So thanks for having me, and thanks for having this important conversation.
Absolutely. Absolute pleasure, and really good having you here today. Next up is Simon Dippenaar. He's the founder managing partner of Simon Dippenaar and Associates. Simon is a seasoned eviction law specialist representing both landlords and tenants, and he offers a grounded, balanced perspective from inside the courtroom. Welcome to you, Simon.
Thank you, Neale, for having me again. It's a pleasure to be a panelist on this important topic. I think there's a lot of fear and frustration out there in the marketplace about these laws. But like anything, once we receive information and education on these topics, it can become clearer, and we can debunk some of the myths that cause unnecessary anxiety.
Yeah, absolutely. Great having you, Simon, as well. And last but not least, we've got Ismaiel Mohamed. He's an eviction and rental law attorney for MML Incorporated, and he's got years of litigation experience in high-profile cases, and he brings sharp insights into how PI functions and often fails in practice. So welcome to you, Ismaiel.
Thank you, Neale. Always a pleasure to be on one of your panels. And yeah, definitely agree. It's a very important conversation we need to be having, because education is the most important tool that any landlord or tenant will have in their back pocket when doing anything involved in real estate. Thank you.
Absolutely. Great having you here, Ismaiel. And so let's dive in and let's start off with the constitutional rights versus legal realities. And Martin, we'll start with you in terms of the PI Act. I mean, does the PI Act, in your view, violate Section 25 of the Constitution, which guarantees the right not to be arbitrarily deprived of property? And maybe you can also give a little bit of background to PI Act itself.
Yeah, so I mean, the idea of eviction law is not a new thing. This is something you find all across the world, and where you do find it, it has to do with someone went and lived lawfully somewhere, like a tenant, and then for some reason or another they couldn't pay any longer and they were evicted, and that provides a legal framework to deal with that problem in a fair and humane way by the owner without violence and so forth. That is the idea of eviction law. In South Africa, it works quite differently. So we have Section 25 of the Constitution. It says that no one may be deprived arbitrarily of their property. It guarantees the right to private property for all South Africans, rich or poor. This is a largely formalistic fantasy, unfortunately, in practice. And then we have Section 26, which is what the PI Act is based on, which says that no one may be evicted from their home without due process of law, court order, and so forth. Unfortunately, PI doesn't really meet, in my view, that constitutional standard. So you gave the full name of the act. It's the Prevention of Illegal Eviction from apparently and Unlawful Occupation of Property Act. That is a misnomer. It is misnamed. There is a very short kind of almost dismissive view in the first provisions of the PI Act that says, well, anyone who solicits someone else to unlawfully occupy land, they have committed a crime. But in fact, the majority of the act is all about you as a landlord should not, in effect, vindicate your property rights. So it doesn't really do much in the way of protecting your property rights. So in that sense, yes, it in a large way does tolerate and allow the arbitrary deprivation of property owners. So it's effectively countenancing trespassing and making it very difficult. I mean, we can always say that, yes, you have the right to approach the courts and so forth, and that's a very important remedy, but not all property owners will always have access to the courts. The fantasy that we don't have courts with backlogs, the fantasy that we have enough judges, this is just not practical reality. In a very large degree, property owners are left out in the cold, especially if they're not high net worth. And the Constitution is supposed to also protect their right to their private property. So no, we at the Free Market Foundation have serious reservations about whether the PI Act balances the necessity of the law prohibiting trespassing and the requirement that owners respond humanely and proportionally to any kind of trespassing. There is an imbalance here where the law clearly leans very heavily in favor of those who never had a lawful reason to be there. Unlike a kind of a tenant who paid and then couldn't pay anymore, this law protects people who go onto land unlawfully and then decide to stay there. And that's a problem.
Absolutely. Thank you for setting that scene there, Martin. So, Simon, you've worked with both landlords and tenants in your practice. I mean, what are the most common challenges the PI Act creates in real-world eviction matters?
Well, it's a difficult piece of legislation to understand and to interpret. So, firstly, if you're a landlord, you're going to have to do your research into what a potential eviction is going to entail. So you have to, before buying property in South Africa and renting it out, you need to do some type of legal risk assessment. So if you're going to have a tenant that's living in property, one of your properties that you own, paying rent or defaulting or breaching the lease agreements, renting themselves into an unlawful occupier position, they refuse to leave, and now you have to approach court to get a court order, you have to understand that there is a process. So justice requires or should generate a sense of dignity, both for landlords and for tenants. But dignity also requires us to respect a process. So the PI Act has been extended not only to protect squatters or unlawful occupiers, but also tenants that are in breach of a lease, who've had their lease cancelled, who no longer have a legal relationship with the landlord. So it's been extended to that tenant-landlord situation. So I say tenant, you're not really a tenant when you become an unlawful occupier, because if you use the word tenant, it implies that you have certain legal enforceable rights and obligations. So what landlords or property owners have to understand is that if they do rent out their property to a tenant, they do need to interview the tenant first. They have to do all their checks and also the vetting process to ensure that this type of person isn't a bad faith actor. If they are a bad faith actor wanting to take advantage of the process, then that's where the problems arise. That's where it becomes difficult for one to exact a sense of justice and dignity from the application of PI. What makes it even more difficult for landlords is not necessarily the PI legislation, but also the court system, how these cases are allocated, how busy the courts are, the administration of that court process, that civil litigation process with certain timelines, certain court rules, and obviously court availability. At this point in time, all eviction matters are heard in the same court other matters are heard in. There's no specialized court that sits to hear only eviction matters. So evictions can be done relatively easily if you are dealing with a good faith actor. But it becomes more complicated when you're dealing with somebody that has a malicious or selfish, call it a narcissistic intention. But that's all litigation. You don't go to court if you're dealing with a reasonable or fair person. It's not always like that. In this situation, you've got a private property owner's rights, which is enshrined in the Constitution under Sections 25, versus a relatively, arguably vulnerable tenant or unlawful occupier that's trying to exercise their constitutional right to adequate housing. So there's that public need, that social political situation versus the private property ownership right situation. So a balance needs to be struck between those two. PI tries to achieve that balance by setting out the process, how to draft documents, how to serve documents, how to come to court, how to satisfy a judge or a magistrate that you're not in breach of any of those constitutional obligations. It's a whole complex procedure. So landlords, in summary, they struggle with the complexity of the PI process. It can be easily circumvented or managed if you deal with a specialist such as Ismaiel, or maybe myself as well. That makes it easier. You cannot brief any ordinary attorney that doesn't have experience in these matters. The timelines, the service requirements, the tactics that you have to mitigate and anticipate at court hearings, these are all things that require experience. So it's almost like an holistic legal service that you have to offer landlords, to be honest, not only about procedure, technicalities, but also how to deal with potential delay and obstruction tactics by bad faith respondents, as you would call it, or bad faith occupiers. Tenants also will struggle with PI. It's complicated. They may not have the resources to hire an attorney to understand how to oppose an eviction. However, with that said, they don't necessarily need access to legal representation to have their rights protected in a way. Because if they represent themselves, often what happens, if they arrive at court and they say they don't understand the documents that they read, they don't understand how to file opposing papers, a magistrate or a judge will usually be quite lenient and allow them time to either appoint a legal aid attorney or get an attorney appointed by the Legal Practice Council on a pro bono basis. That in itself is not the song that a landlord wants to hear, unfortunately.
Yeah.
But because this is the saving grace, we live in a country where we can accumulate wealth. Land is a difficult topic. It's wealth, it's inheritance, it's identity, it's blood. It's a controversial topic. Okay, there's the social, historical injustices that took place that everyone seems to be paying for in some shape or some form. And we're trying to manage those situations, especially with other bills like the expropriation bill, which I'm not going to mention or elaborate on.
Not for today.
But tenants will struggle to understand how to oppose an eviction application. But as I said, the trier of fact, the judge or magistrate will intervene because the judge wants to try and balance those constitutional rights of a right to access legal representation, the right to access a fair trial, and then also, more importantly for the tenants, to respect that right of adequate housing. So it's not hopeless. If you have an attorney that knows what he's doing, if he's a skilled negotiator and also a mediator, you can resolve these situations quite practically and cost effectively, especially if you adopt a type of commercial Ubuntu attitude. Maybe I should kind of bring my answer to a close there, otherwise I'll be speaking for the entire seminar. But essentially, landlords struggle with the complexity, the time, and the costs of these applications, especially if they're opposed, but it's not completely hopeless. And then tenants, good faith tenants will struggle with the complexities, technicalities, but they can be helped by legal aid, but bad faith ones can unfortunately push these matters out for quite a long time. And that's why it's important. If you're going to invest in property in South Africa and rent it out, you need to vet your tenants properly, you need to draft that lease agreement properly, and then you need to be very proactive on enforcing that agreement and that process and holding the other side accountable. It can be done.
Great. So good advice there. So good faith tenant, use a specialist for PIACT specialist, very important. So Ismaiel, I mean, you've also handled high profile eviction cases. I mean, what impact has the PIACT had on lawful owners trying to reclaim their property from the bad faith occupiers or actors, as Simon has put it?
Thank you, Neale. Okay, to start off with, well, my opinion and my view on these issues, I want to touch on what Simon also said. It's not impossible. It might seem a bit complicated. It might sometimes seem a bit hopeless, but it's not. There really are mechanisms and there are processes in order to maintain the right that the landlord has over the property. So again, if we look at the constitutionality, Section 25, right to, let's call it like right to property, and then Section 26, which is right to adequate housing. Now, where this goes further when we come into the discussion, when it comes down to PI, is when we're standing in court, and I mean, Simon will back me up on this, we're standing in court, we've got to present our case to the presiding officer, whether it be a judge or magistrate. That argument needs to cover certain aspects. Now, those aspects are set out in the PI Act from the side of the tenant or let's call them the respondent when we're standing in court. And those are things such as, is it a household headed by a woman? Is it, are they elderly? Are they disabled? Are they children? These are all things that are set out in the PI Act. Yet the Act goes further and the case law itself goes further and says that the presiding officer needs to look at all circumstances. And those circumstances then takes things further. I mean, one of the things that we often come across when it comes to the children is not just the fact of whether there are children in occupation, but it's a case of where do these children go to school? How close is the school to the premises that is currently being occupied? Because the presiding officer will take this into account to say, okay, the children now need to move substantially further away from the school. Are they going to grant an order during the school term? Are they going to wait for the school term to come to an end? So there's a lot of things that need to be taken into account from the respondent, from the tenant side. The PI Act does not hold the same standard towards your landlord. It doesn't set out a list of these are the circumstances of the landlord that needs to be taken into account. For example, is there a bond on the property? What are the other expenses on the property? Is there a occupier, maybe the landlord themselves, due to personal circumstances, that they need to move into the property? So yes, these are arguments that we can put to the court, but these are not things that the PI Act sets out. It only sets out that the circumstances of the respondent or the tenant needs to be looked at. And that's quite, in my view, it's a glaring hole, which does cause that bad faith occupiers can use this to say, what about me? What about me? What about me? And the landlord needs to basically stand around and go, but I also have rights, which we need to make this argument to the court without being able to say, in terms of section such and such of the PI Act, this is the argument the court needs to take into account. And as I say, that's where our difficulty comes in. But I want to end it again by saying, not hopeless, can be done, but we have to take these things into account when launching these applications.
Absolutely. Thank you for that as well. So to our audience, there's a Q&A box. Got any questions, put them, fire away with your questions. We want engagement, very important to get your feedback. Martin, coming back to you, let's talk a little bit about the sort of investor and market impact. And we've seen that the Free Market Foundation has long championed property rights. I mean, how does PI affect investor confidence in South African property markets?
Yeah, so one has to look at legislation like the PI Act kind of holistically in the context of other factors. I think here there's kind of the factor of enforcement. So if you took, let's say you took PI Act, you applied it in Sweden or in the United States, it wouldn't be that much of a problem. South Africa has an age-old issue with enforcement. The police explicitly are required by Section 205(3) of the Constitution to protect and secure the inhabitants of the Republic and their property. So there is that requirement on the police service to ensure that if there is a kind of a trespassing, and I'm speaking very specifically in the context of land invasions here, that is certainly a duty that the police have to stop. Now, we've recently read stories of the police actually participating in land invasions, helping people invade land. So I don't think if you're an international investor seeing that, especially if your investment kind of implies the acquisition of property, that inspires much confidence in you. If you look at the guides on how to kind of adapt to the PI Act, everyone recommends that you have to wall everything in, you have to make sure people can't come onto the property. These are not realities that investors face elsewhere in the world. There is no pressing and dare I say, political kind of feeling of entitlement to settle on open land. That is something that is very much emphasized in South Africa. And investors obviously don't want to spend any time whatsoever on stuff like this. They want to make money. They purchase property. They invest in property to develop it, to make money. And then they have to often deal with this type of thing. And so that's one factor. You have to look at enforcement. Investors know that there is no enforcement. The other factor is just that the PI Act in its anti-property rights kind of nature is not the only thing that the South African government has done. Simon mentioned in passing the Expropriation Act. We won't get into that, but there's also the misnamed Protection of Investment Act, which says that you're not entitled to any additional protection as an investor. So that made bilateral investment treaties basically illegal in South Africa. And there's various other pieces of legislation, various other kind of regulations that if you take them together with the PI Act amount to the South African political class saying, listen, if you are a property owner or a land owner, we are not on your side. Understand that we do not like you. We do not want to help you. And instead, kind of as Ismail kind of just explained, there is a legislative taking of sides on the part of tenants. And I think Simon made an important allusion earlier when he said that tenants are debatably the vulnerable side. I think it's clear that in the context of land invasions, the owner is the vulnerable person. I think almost always. You look at the recent example of the Tygerberg Raceway in Cape Town, where people say law enforcement is better, but alas, there the owner, and well, it was a municipal property, but the person leasing it really went out of their way to get the police involved, to get private security involved, and still they were deprived of that property, and the city was deprived of that property. So when it comes to land invasion, specifically when there is a political kind of incitement going on around it, which is often the case, the landlord is the more vulnerable property. And certainly serious investors understand this. They know that they're going into this kind of at a disadvantage unless they invest more in walling everything off and appointing specialized private security and having all those extras. which they do not encounter when investing in other jurisdictions. So that is just a way to say that South Africa has done many things, and the PI Act is part of this kind of framework of making South Africa a very unattractive investment destination, whereas other countries try and go out of their way to make it an attractive investment destination. So this is certainly a problem, and it beyond any doubt necessitates reform.
Absolutely. I mean, that's how you're going to attract investment into that country at the end of the day. There's got to be confidence in the rule of law, and it has to be carried out efficiently for investors. So, of course, Simon, I mean, let's talk a little bit about, is there sufficient clarity in our courts interpret unlawful occupation and just and equitable outcomes under PI? I mean, just recently we saw how municipalities, and I'm talking about sort of in the COVID period, I mean, how do they and how they actually handled responsibility to provide alternative accommodation in eviction. Can you maybe just elaborate on that? So first of all, just how it's, how the courts interpret that, and of course, and then secondly, in terms of how municipalities typically handle that responsibility. And let's talk about those gaps.
Sure. I mean, just to follow on from what Martin said, he identified a major weakness of the South African legal landscape and property ownership landscape, and that is this risk of land invasion, which will result in a protracted, lengthy, expensive, complicated process, when now suddenly the property owner has to now almost take on board the humanitarian or constitutional obligation by at least waiting for the process to be finished while the judge or the relevant municipality steps in or compensates them for it or provides the alternative housing. This is maybe good to bring in now, given the topic of the discussion. This is exactly why the Democratic Alliance has proposed these 3 amendments to the PI Act. The first one was to criminalize the syndicates or bad faith actors in the community that have maybe malicious political agendas, who knows, okay, from committing or inciting or encouraging land invasions, unlawful land invasions. So if that law can be passed, I'm sure that the optics of the South African legal property landscape will be brightened ever so slightly. So if there's going to be a criminal sanction to that type of behavior, obviously it'll act as a deterrent. People have to be caught, though, for it to be a deterrent. These things have to be enforced. Begs the question about effective policing. Okay, it's not necessarily the punishment that people are scared of. They're actually more afraid of being caught from doing things. I've dealt with a mass eviction matter as well in the past, if I can just digress ever so slightly. There was a property in Philippi. This was about 2015. There were about 160,000 people eventually migrated across onto 3 commercial properties. And within a matter of moments, they had erected structures which had roofs, and a community was formed, even though the municipality, which it does from time to time, mandated the so-called infamous red ants to try and demolish the structures before an arguable house was created. And for those private property owners, it becomes disastrous because they can't take the law into their own hands. You have this mass group of people that are now exercising certain constitutional rights. They say that they were fleeing violence and also insecure and also dangerous territories. And it ended up turned into a case that took many years to resolve. So I'm not going to get into it now. Essentially, the conclusion of that case was that there was arbitration. It went all the way to the Constitutional Court, back to the Supreme Court of Appeal. The judges asked the city to enter into negotiations with the private property owners to buy them out of the land, because they couldn't evict 160,000 people. I was actually representing the unlawful occupiers pro bono in that particular matter. But if there is a law like the DA suggested, I don't know if it's going to necessarily help with that situation. I think that's maybe an exceptional outlier type of case. But for these bad faith political actors that are drumming the war drums and trying to put undue pressure onto municipalities, I think it's a real solid assertion of legal boundary to try and prevent that type of activity. But your question was about what is just and equitable in the context of evictions. it's not necessarily a closed list. I think each case needs to be decided on its own merits. To oversimplify it, there are some clauses within the PI Act that Ismaiel has mentioned that we have to look at to determine the nature and extent of the vulnerability of the unlawful occupier. We also have to we have to weigh the prejudice that the unlawful occupier will incur as a result of an eviction order being granted against the prejudice that the landlord will incur as a result of continued unlawful occupation of his property. The landlord has a right to use and enjoy and rent out his property in South Africa. How long does he have to wait? Ismaiel already went through some of the categories. I'm not going to repeat them now. But also, one of the things that a judge has to take into consideration is there available alternative accommodation for this person? If there's no defense to this eviction application on behalf of the respondent or the unlawful occupier or the former tenant, then is there a place that they can actually go to? Some places there always is. Cape Town, not so easy. Depending on how many clients of yours are buying property, of course. So there is a bit of a housing supply crisis within the Western Cape, especially in the prominent areas, but I don't think we're always dealing with those areas. There's not often evictions from Camps Bay mansions. I think a lot of people might be in fear of that type of scenario, but it's usually not those type of areas that are dealing with these issues. So then the question becomes, okay, well, how do we prove that there is an availability of alternative accommodation? Well, you can just go onto Property 24 and see what's being sold or what's being rented out. Simple as that. And we include that in our affidavits on behalf of applicants. But there's also something else that's happened. There is some case law, the City of Johannesburg versus, I think it's Tide 74, talked about if the eviction order is going to result in the respondents, the unlawful occupiers or the squatters, if it will result in them becoming homeless, then we need to know about it. And we need to start taking some kind of mitigating action. So this is why the municipality is always a party to these applications, because they're governments, they've got an interest and also a constitutional duty to ensure the respect of the constitutional right to adequate housing. Then, which leads me to answering the next question about the municipality involvement. Yes, they get asked to file reports, but it's not a proactive thing that they do. They only do it when a judge asks them to do it. And that can also cause delays. Sometimes it's not delayed because some municipalities have template reports that they send out or template responses. Maybe Ismaiel can also agree with me on that if he's had that experience. I've experienced that more up country, to be honest, where they reply and they say, oh, we don't have enough information. We can't really make a determination. Yet all the information's in front of them in the application and the founding affidavit, the notice of motion that we've drafted. Okay, more in the founding affidavit and annexures. So it requires one to be extremely careful in litigating over these issues. One of the other most important things to mention when it comes to just and equitable considerations is that if you have, especially for private property owners watching, if you've got a tenant who is in breach of their lease for not paying rent, is the most common example, you cancel that lease after the proper legal notification process. That's a whole seminar, by the way. Okay, if somebody doesn't pay rent and you want to take them to court, it's very important that you send them the right type of legal notice to give them a chance to either fix it, depending on which laws apply, like the Consumer Protection Act. I'm loath to mention it because I might get questions about it now, okay, which now does apply to the tenant-landlord situation. Okay, tenants are consumers of property services. Don't ask me why. Okay, maybe that shouldn't be minuted. I should know why. Okay, and I do, but I'm not going to get into it now.
No.
So you have to send these notices properly. You have to cancel. You have to notify them of the breach. You've got to cancel properly to then render them from being a tenant, a lawful tenant, into an unlawful occupier. That answers your question about what unlawful occupation actually means. Essentially, it's trite. An unlawful occupier is somebody that doesn't have a legal right or title to stay on the land. Doesn't. So when you rent out your property to somebody, they become a quasi-owner for the period of the lease. the period of the agreement. Okay, so they kind of step into the shoes of the owner for a limited period of time. Yes, they can use and enjoy, and depending on the lease, maybe grow things and enjoy the fruits, etc. Maybe sublet if they really can, but usually that's excluded. But there are limitations and there are conditions which have to be respected. So you'll render a tenant into an unlawful occupier once you've cancelled that lease agreement lawfully through a proper pre-litigation notification process, which agents don't usually do very well. Okay.
Yeah.
Eviction lawyers that argue matters on technical grounds that are raised by legal aid when you have an opposed eviction application, that's the kind of person that should do it. It's like a divorce lawyer drafting an anti-nuptial contract. Rather let the person that deals with it at the end to actually draft it at the beginning. But I think in summary, the issues with the municipality is that sometimes they do provide reports about the availability of emergency housing and supply some building materials, but more often than not, there's good cases, there's bad cases. We saw in Cape Town, there were the unlawful occupiers outside of the castle, and there was the tent city outside of the Sea Point police station. Okay, these things take a long time, but I mean, you saw all the videos by the mayor about the availability of these alternative places, and they look pretty decent. Okay, but that's also maybe some posturing taking place and maybe an exception rather than the rule. But it's generally a bit disappointing. And what I've tried to do in my eviction applications with the municipalities is try and engage them as quickly as possible. Not that they're going to listen. Okay. If I ask them for a report early on, because I know I'm going to need it in a couple of months' time, that doesn't really hurt. Whether they are going to respond, it's another question. So it is a bottleneck. Okay, it's not always completely bad, but it can be a disappointing experience when it comes to receiving a report on the availability of alternative accommodation. And you only have to consider giving alternative accommodation if somebody has been in unlawful occupation for more than 6 months. Okay, so if you've got a tenant, you've cancelled the lease, okay, you have to proactively and with speed of execution get the eviction process going. Because if they are in unlawful occupation longer than 6 months, then the constitutional duties become more onerous. Okay, maybe Ismaiel can pick up on that point.
No, absolutely. So I think, look, I'm just aware of time, but what I want to do, just do a shout out to our audience out there. If you've got a specific case or specific question, this is the time to put it into the Q&A box, which is on the far right-hand side of your screen, to fire away. We can have the questions, because this discussion could go on for very long, and obviously it's very important that we could cover all the aspects. So Ismaiel, coming back to you, I mean, Martin spoke about the Tygerberg Raceway scenario. I mean, let's talk a little bit about, how often is PI being misused to delay justice, and are judges sufficiently empowered to deal with the abuse of process?
Okay, thank you, Neale. In my view, I don't believe that judges are sufficiently empowered to deal with the delay. And that stems from the fact that the PI Act requires that an application be brought to court. Right? We're not going to necessarily go into the legalities of whether it's action or application, but let's just work on the fact that these things are usually done on application to court. But in doing that, you need to follow the court rules as to how our applications launched. Yes, there are specific requirements in terms of the PI Act, such as the 4.2 application, which needs to be done. I'm not going to go into the technicalities, except to say that you do need to follow the normal court rules. Where the difficulty comes in is that the PI Act specifically sets out that a normal application is launched under Section 4 and an urgent application is launched under Section 5. And in that, urgency is a very specific topic under PI. So, for example, I mean, 90%, as Simon will agree with me, most of the cases that go to court is a tenant that hasn't paid. That's not deemed urgent by the court because it cannot be launched under Section 5 of the PI Act. It needs to be done under Section 4, which means although the application itself, the notice of motion when drafted, will set out time periods in which the unlawful occupier needs to put in a notice to oppose, needs to file an affidavit. These things are supposed to be done before the matter is heard in court, which means the legal representative would have a copy of the defense of the unlawful occupier when walking to court on the first day to say, this is the defense they're bringing. We would have most likely filed replying papers by then. And the court is then empowered to move the matter forward efficiently. However, because these are launched in the normal course, your respondents, your unlawful occupiers, they don't file any opposition. They show up in court on the day. So the matter is, for all intents and purposes, unopposed. They walk into court and they say, oh, I'm here. I want legal representation, or I want to oppose it myself, or whatever the case may be. Now they are given a further opportunity, a further delay. Go find a lawyer, go file papers, there's one of 1,000 things happen from them, which only goes so far as to delay the process. And in a case like this, as much as we can argue, the application was served on a particular day, they should have filed their papers by a particular time. They haven't done this. And now the landlord is being prejudiced even further by the delays. Our presiding officers, their hands are tied. Constitutionally, they must give these people an opportunity to find to find legal representation or to file papers. And through that, we are not empowered to say, what about the urgency? Because we have not launched an urgent application. And yes, there are mechanisms to convert an application to urgency. But again, very exceptional circumstances can you actually do this under. So, yeah, as I say, I'm not of the view that our presiding officers have the necessary power to find the bad faith players and use process to actually expedite the matters. Their hands are tied, our hands are tied, and we've got to follow the process as it is.
Okay, great. So, Martin, I want to bring you in here. I want to fast track to our topic at hand, which is PI Act on trial. Should the law be amended? We've heard a lot from the litigants. They've had a lot to say, and thank you, guys. Those details are important. We just the time is not so good. So let's talk about, if the PI Act was repealed or drastically amended, what legal safeguards would you recommend to still protect vulnerable occupiers in bad faith evictions? So maybe we can start looking at policy, practice, and the way forward, and what should be repealed or amended.
Yeah, sure. I guess I think a good place to start is just with the DA's proposed amendments. I think I agree with Simon that it's a good start. I think that it would assuage investor worries a little bit. My worry is that there's two things that it should do that it doesn't do. It doesn't go quite far enough. The first thing is that there should be a fundamental distinction in our law between, let's say, squatting with a lawful causa. So essentially someone who was renting and now they can't pay rent anymore. So they were there initially with permission. The landlord knows about them. The landlord knows them and all those things. That should be one area of our law. And I think 100% those tenants do require some level of legal protection, and then we could get into a little bit of that. But then there is this thing about land invasions. These people who go onto land have no legal reason to be there. The owner has never heard of them. They wake up one morning and there is now a community on the property. So I would say that any amendments to PI need to kind of divide it in two, basically. And then when it comes to land invasions specifically, this one part, the right of counter-spoliation, that is effectively the right of an owner to resist the occupation of their property, must be extended. So all of us have this right. If you are sitting on your porch and you see someone coming onto your property and they start setting up a tent, you are allowed by law to go out and resist within reason, within proportion, to resist that happening. You are allowed to use force to some degree. So that is recognized. However, the law says that once that thing, that tent or whatever, becomes a home, that right disappears into thin air. Now, that is very arbitrary, in my view, and the way that kind of homes come into existence under our eviction law seems to me to be very problematic, to put it lightly. So I would say that this law, specifically as regards to trespassing and land invasions, your right to counter-spoliate has to be certain expanded into not just a few minutes, but hours, days, weeks. You have to have that right to counter-spoliate, to get that person off your land. Of course, don't shoot them, don't kill them. There's always that kind of proportionality that must apply. So those are kind of where I think the DA's amendments don't go far enough really to solve the problem, and I think it is a solvable problem. Now, as far as protecting the vulnerable, I think that you specifically phrased your question in light of bad faith evictions. I don't think anyone who occupies property in bad faith should have any protection. I think they should be left out in the cold as far as the law is concerned. But certainly as far as people who are down on their luck in good faith, I think our common law does enough. I know people tend to common law gets a bad rap, but I think where the common law says that you must always, as a general principle, act reasonably, you may not endanger people, you must act within kind of proportionality and so on. I think that is sufficient. I think that is fine. So the state has a responsibility to provide housing. That's how it reads Section 26. I'm not sure I agree, but it has understood that right in our constitution to mean that the state must provide housing. So there is that protection. You are not legally allowed to be homeless in South Africa effectively because the state is supposed to provide housing for you if you are vulnerable. I know the courts have limited this. The Constitutional Court has said that it doesn't necessarily mean the municipality has to provide alternative accommodation under all eviction applications, but our government is very keen on this power to provide housing. So as far as protection goes for unlawful occupiers, I think it can't get any better than that, to say that the government must come and give you a house. And then we have state programs for that. Of course, our government has mismanaged its budgets every single year for the last 30 years. So that's also to some degree something of a fantasy. But that is ultimately a political question, and the solution to that is going to be political. So do I think that the law must provide additional protections for vulnerable tenants? No, I think we've gone over the line and potentially provided too much protection for vulnerable tenants. And I think if we want a good, sensible reform that does observe human dignity, but also crucially protects private property rights for owners. And again, I must emphasize the right to private property is something that poor people also have. And how poor property owners kind of deal with unlawful tenants on their property is a nightmare. Them being able to afford legal counsel is a stretch. And if they go to the Human Rights Commission or to legal aid and say, hey, I am poor, I have property, I want to evict someone from my property, they will be told to take a hike. So that is a huge problem. So the right of property ownership for poor South Africans and in general is crucial. And I think we just need to swing the scales back in that direction because simply you have to protect this right if you want a flourishing society.
Excellent. Some good advice there. So we got 3 questions. I want to deal with them, and I think actually each one could be handled by each of the 3 of you. So starting with the first one from Anonymous, he said, if someone has had a shack quickly constructed and then put in a few pieces of furniture, up to what point can that still be regarded as invasion that doesn't require a court process? Simon, do you want to handle that one?
Sure. Look, this is the sensitive topic, and it's also an area in which there's been a large degree of abuse. In our dry run, we actually touched on it. But essentially, if you've got an unlawful occupier, or maybe not so politically correct to say a squatter, coming onto your land and erecting a structure with a roof, with personal effects, a mattress, a fridge, then arguably speaking, as the law stands, they have started to exercise a right to adequate housing. They're using your property, be it unlawfully, as a place of residence, assuming that they've got nowhere else to go. So it seems like the new tactic is that people, instead of creating a shack, for lack of a better word, they are erecting tents. And that can be done in a couple of seconds. And if one doesn't intervene quickly enough, then you've got a big problem on your hands. So there are remedies, anti-spoliation remedies, urgent remedies, or interdicts that could be launched. But this is a difficult area now for lawyers and property owners. Okay? At what stage, how long are they allowed to be there? What type of structure should it be? These are question marks. I don't think it's been completely settled. Ismaiel might be able to also elaborate, but there are lawyers out there that are very compassionate towards unlawful occupiers and asserting their rights, that are quite proud of the fact, in a strange way, that they were party to developing the law in this way to allow this type of situation to take place. That for me is chaotic. So I think there needs to be a development in that area. Like Martin said, I think there needs to be stricter conditions and criteria put in place, timelines, the nature and extent of the type of structure for property owners to be able to assert those remedies of preventing an unlawful trespassing before somebody has entrenched themselves. So it happens on government land all the time. Sea Point 10 City outside of the Sea Point police station is a prime example. It took a long time to rectify. But it's up to all of the private property owners to secure their property, to monitor their property. But yes, there is room for reform, and there is also room for there to be a greater sense of justice under these circumstances without having to give the unnecessary dignity considerations to undeserving people. In fact, in many ways, I'll be mindful of the time, sorry, Neale. In many ways, we launch an eviction application. It's two prongs. We first have to go to court by ourselves to convince a judge that we've respected the constitutional rights at play. Have we notified the occupier of their rights, of the process, of the timelines, of how to respond, that they've got a right to legal aid or legal representation, or legal aid if they can't afford legal representation, rather. And that Section 26 covers them when it comes to adequate housing rights. You've got to say all that stuff. All that stuff must be in writing, served by the sheriff personally on them. Then a judge will sign off and allow you to come to court for the actual eviction hearing, which is either opposed or unopposed. So my argument might be, and this will be constitutionally controversial, but in favor of defending legitimately, in my opinion, private property rights. Why cannot we build into that process an evaluation of whether this particular respondent or occupier is a good faith or bad faith actor, or a tenant versus a unlawful occupier / squatter evading some kind of violence or unsafe environment? Why can't that be a test for us to be able to continue, or a test to justify urgency under certain circumstances? Many people will say, oh, that's going to be abused, or there's too much power now in the hands of the applicants. And everyone's got a constitutional right to access justice and to a fair trial. How can you find somebody guilty of acting in bad faith without a criminal type of trial that fetters the right to the presumption of innocence? But under these circumstances, there can always be a justified infringement of certain rights under certain circumstances. So that's something that can be done.
Great stuff. Thanks, Simon. And the next question, I think, Ismaiel, you can also handle that. There is a request. Could we perhaps briefly touch on the correct legal process of cancelling a lease agreement? I know Simon brought up and the grounds to enforce a lease cancellation, but you also involved. So agents generally do not understand the correct pre-work actions required before an eviction's turned its pro. Ismaiel?
Okay, Neale, I'm going to keep it as brief as I can.
Yes,
as
thank
Simon
you.
correctly said, this is an hour-plus conversation. But
or maybe we should arrange to do one.
By all means.
That's a paid consultation question, by the way.
Okay, so I'm going to touch on the two ways that a lease can be cancelled. Okay, one of the ways is in terms of the Rental Housing Act. The Rental Housing Act is very clear. A lease agreement without a fixed term, so a month-to-month lease, can be cancelled on a calendar month's notice to the tenant. That's all it takes. So if you would send a tenant a notice today, being the 7th of August, to be out of the property, they need to get a calendar month's notice, which would be our month of September, because that would be the full calendar month coming up. So we would say to them, here's your notice, you need to be out at the end of September. If they leave at that time, fantastic, job's done. They've abided by the notice. If they don't leave, automatically on the 1st of October, they are deemed unlawful occupiers, and the PI Act then comes into effect. The other way that a lease can be cancelled, let's look at a fixed-term lease again. A fixed-term lease cannot simply be given notice to say, please go away. A fixed term lease, you've got to find your breach. And your most common breach is rental hasn't been paid. And again, to come back to, as Simon said, the Consumer Protection Act does come into effect here. And I agree with Simon. I don't know why. I do know why, but let's not go down that. In my view, it shouldn't come into play, but it does. And because of that, we now need to send out a notice to the tenant saying you are in breach of your agreement. Here's a 20-day notice to pay in terms of the CPA. If they do not rectify their breach within those 20 days, you can then cancel the lease. And as I say, in short, I know we are running out of time. Those are the two ways that a lease agreement is properly cancelled. One, by giving a calendar month's notice when applicable, and one, by sending a breach notice, failure to breach, and then cancelling. Again, I'm going to put the proviso on there, when applicable.
Okay, great. And I think your call for doing this in more detail, I think we should actually do another more detailed webinar on cancelling a lease, because there's a lot of moving parts there. So we can certainly do that. But Martin, I want to bring you in here. And there's a question here from Rodney, and it's a good one. And he says, can SANCO, and SANCO, the South African National Civic Organization, typically I think it's a political organization. I think it was established alongside when South Africa sort of went through the whole apartheid sort of regime. I'm sure you're very aware of that, Martin. But the question is, can SANCO prevent eviction from taking place? And then secondly, Rodney added, if I bought a property through the sheriff auction. So do you want to maybe just do the first part? Can SANCO prevent eviction from taking place?
Yeah, this is an interesting question that might conflate can and may. Can a political organization prevent an eviction from taking place? Absolutely. The EFF does it every single day, and it's very problematic. So yeah, I think they probably can. Should they? I don't think so. I don't think SANCO just per se has legal standing to do that, unless they're kind of they're also incorporated as some kind of association that represents tenants and so on. So I highly doubt that. I'll stand corrected by the practitioners here. So no, I think they probably may not. And certainly, I think if there's a sheriff's eviction kind of auction already taking place, I think that necessarily implies that the legal process has kind of already run its course to some degree, and that it's the chance to kind of legally stop an eviction has probably run its course. So no, I don't think so. And let me add that I really hope not. I really hope that SANCO wouldn't be able to prevent evictions under these circumstances.
Okay, great. I think it's well answered. We've got two more questions, and then I think we're going to have to say, your final thoughts. But it's been a really good discussion. I know we're probably going to have the discussion again. So the one is from Demetrius. It says, one proposed amendment has been mentioned. What is the other two? Who wants to give a crack at that? Simon, do you want to?
Yeah, well, sure.
And can we do it in a minute, Simon, if you don't mind? I know it's tough.
And they resolve a lot of the issues that we've discussed. So firstly, you criminalize the unlawful land invasions. Okay, you criminalize the incitement or the encouragement of those type of activities. Secondly, it's about making sure that the municipality provides their reports under certain times, and also provides alternative housing, or performs their duty under certain time limits. It's not open-ended. We don't have to wait. There's no uncertainty there. So that also ties into the answer that I gave about the template letters we receive from time to time from municipalities. So it holds them to stricter account for certainty reasons, for conclusion reasons, to get a conclusion rather. And then thirdly, it creates, and this is, I'm not so sure to what extent, but it creates more criteria for a judge to consider when determining what's just and equitable. Perhaps Ismaiel can also give me can elaborate on that point.
No, that's good. And then just the last point. So Ismail, I just want to, I know I'm just conscious of time, but if after 20 days they do not pay and you cancel the lease, do they have to vacate immediately, or do you give more days to vacate the property? We can maybe handle this in the longer session that we're going to have.
We can handle the longer session, but in short, I can answer this very briefly.
No, please do.
The PI Act comes into effect when there's an unlawful occupier. Right, that's it. Unlawful occupier leads to the PI Act. When the 20-day notice is sent and the lease is then cancelled, so you haven't rectified the breach in 20 days, we hereby cancel the lease. That person is now deemed an unlawful occupier because they have no lease or right to occupation. And that triggers the effect of the PI Act, and we can launch immediately. We do not need to give further time. 20 days, no rectification, cancellation, and go to eviction.
Is that the same for residential and commercial?
Residential and commercial. If there's no contract, you have no right to be there. We now may approach the court. There's a lot more that can be said about this, and I think we are out of time, so I'll hold that for the next session.
No, absolutely. We will do that in future. So what I'm going to do is finish off with 1-minute takeaways from each of our experts here today, starting with Martin. Martin, maybe you can leave everybody with your message to policymakers, also investors, about PI Act's future. If I could just ask for your 1-minute closing thoughts on that.
Yeah, absolutely. So I alluded to this. This isn't just a legal matter. There is a lot of politics involved here and public policy. So if you're interested as an investor, as an owner of property in this country, and in changing the landscape, unfortunately, that does mean more than being reactive. Being reactive is how we got to this situation. So we at the Free Market Foundation would encourage you to kind of roll up your sleeves and get involved. So support organizations like the Free Market Foundation that fight the fight for private property rights. There are some others as well. Fund litigation, public interest litigation, to kind of get better principles of law around the PI Act, I think this was alluded to. You have to state-proof yourself. This is very much a symptom of state failure. So yes, they say build high walls, don't allow property to stand open. And please, I'm begging communities, residential communities, if you see your neighbors moving out, and there they go, and now this house is abandoned, don't sit on your hands waiting. Be proactive in making sure that no one occupies that house and becomes a burden for the community. So kind of final message from my side is you need to be alert, and you need to be awake, and you need to be proactive. You cannot just kind of wait until the problem arises and then go to court, because that's just a surefire way for making South Africa a terrible place to live and to invest. Thank you, Neale.
All right. Yeah, no, thank you very much, Martin. And that's Martin van Staden. He's head of policy of Free Market Foundation. And reach out to the Free Market Foundation. They really are playing a very good, active role, not only in property, but all policy across our society. So thank you very much to Martin. And then Simon, your closing parting shots, Simon. Maybe talk about a reform that could bring more balance or clarity to eviction law. Maybe just your final. You got a minute, Simon?
Yeah, good. Let's start. What's going on? Look, eviction is a pejorative word. It is slightly tainted. Tell people that you're an eviction lawyer, then they think that you're just kicking people out of homes, and that's not the case. It's all based on procedure, due process, the dictates of justice and equity, what's just and equitable. Evictions will obviously expose the powerful versus the vulnerable. It's not only political, social, it's also emotional and psychological. It really speaks to an arguable historical wound. But it's not hopeless. If you manage with power comes responsibility. And if you manage your assets responsibly, you vet your tenants, you've got good advisors, you've got speed of execution in your representation that's seasoned, that understands the tactics and how to mitigate them proactively, you will always get your eviction order. Okay? In some cases, sooner rather than later. But with bad faith actors abusing PI, it's always a risk. And that's why we need to try and discern or fairly discriminate between the type of respondent or occupier you're dealing with.
Excellent. And that is Simon Dippenaar, founder and managing partner. Simon Dippenaar, an associate. Wonderful having you on board again. And Ismaiel Mohamed, of course, your final thoughts, maybe best advice to landlords navigating the PI framework, and your final thoughts.
Okay, my final thoughts are threefold. I just want to touch on what Martin said first, and I agree with him 100%. Because when there is vacant land, as he says, if your neighbor's moving out or there's a plot of land across from you, be proactive. Don't let a foothold be taken on the property, because once that foothold is taken, you will have issues going forward. So 100%, I agree with Martin, and I'm happy that he brought it up. My second point, I want to touch on what Simon said, and it's a lot with the same that I get comments and I get statements from clients and people that I meet. You do evictions. How are you able to do this? Is this not a hard thing to carry? And I always say, but I'm fighting for the little guy because I'm fighting for the landlord. Because that's just the way that the law is based. It's all in favor of the tenants or the occupiers. So yes, Simon, I think we're in the same boat here. And then the third thing, I just want to touch on what reforms I would like to see. And what I would like to see is I would like to see a change in the definition when it comes to unlawful occupier. On the one hand, you've got someone who never had opportunity or never had permission to move onto a piece of land, for example, a land invasion. I think that needs to be dealt with completely separately to where you have someone who had permission, a tenant who just hasn't paid. Because there are many reasons why this person hasn't paid. Maybe they can't afford the 12,000 Rand a month that Cape Town is charging, and they can afford 8,000 Rand a month. Because yes, adequate housing is enshrined in the Constitution, but what is adequate? So I would like to see that change between the type of occupiers that we have, because at this point, PI simply says unlawful occupier, and everybody is painted with the same brush and everybody has the same opportunities. And unfortunately, we don't all have the same opportunities. And
Right, so
that's me in closing.
thank you, Ismaiel Mohamed. He's director of MML Incorporated. Thank you to our panelists again, Martin, Ismaiel, Simon, for your insights today. Thank you all, our attendees, for joining us. I still see there's more than 50 of you on here, so that means that you've enjoyed it. What we've learned today is clear. The PI Act is no longer a niche issue. It's a national concern, and the law must protect both rights and responsibilities, dignity for vulnerable people, and security for lawful owners. And change is inevitable. Our role is to help shape that change constructively. So join us again next week. Not next week, week after, but next week we're actually on a roadshow in East London, in Gqeberha. We'll see you there on the 21st of August again for our next webinar, titled Beyond the Bank, Smarter Finance for Property Growth. Discover smarter finance solutions tailored for your next big move in property or business. Just visit rei.co.za, or there's a link below there that you can click off there. Once again, to our panelists, I think thank you for joining us. We're definitely going to look at doing that longer, unpacking the lease agreements, the cancellation of leases. There's a lot of moving parts there that we need to discuss, and I think it makes sense that we can do that going. To our audience, once again, for joining us. Wonderful having you all. And this is Neale Petersen alongside with my three legal minds, signing off. Until next time, stay informed, stay empowered, and keep investing wisely. Thank you, everybody.